Kohberger allegedly stalked one of the victims. That's false. You knew that was false. For anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false. We do not have evidence that the defendant had direct contact with 1122 or with residents of 1122. But we can put his phone in that area. There are many residences in that area. It's a dense population of mostly college-related occupants.
Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Hi, you guys. How's everyone doing today? Good morning. Good morning. Welcome, Beer Pong. Welcome. How are you? How are you? Hey there, Deborah. How are you doing? Hey, Stacy. Hey, Claire. Oh, I got your screenshot yesterday. Did y'all know that there's a TV license needed overseas for you to be able to watch YouTube? I need to look more into like the logistics of that because that sounds crazy. She sent me a picture of it. But that's wild. That's freaking crazy. That's absolutely crazy. No, I don't think there's a monetary amount for this lawsuit. They haven't put out a monetary amount. And I really hope that that's not the case because the monetary amount would just bother me because that doesn't fix anything. That doesn't fix the FOIA rules. That doesn't fix the bullshit that they're pulling. And I haven't seen a monetary amount. So I don't know. I don't think that's what's going to happen. Yeah. Well, no, it's EWU suing them because they're not doing their FOIAs properly. They're not allowing information to come out that's supposed to come out under the rules. Hey there, Nash. How you doing? How you doing? Hey, Sadie. Yeah, but I just don't know if there's any money to this thing because it hasn't been mentioned. Like we went through a bunch of the filings and I'm going to be doing some of my makeup for the stuff I have to do afterwards while we're getting ready for this because this isn't going to start for another 40 minutes. And I have things to do. But I don't think this isn't going to be a monetary thing. If this ends up being a monetary thing, then I'm going to be really disappointed in the entire process here. Because them getting some sort of monetary situation or getting some sort of payment from this court, whatever, that's not going to fix the problem. That's not going to change anything. That's going to give them back their freaking money for stuff that I can't even find receipts for that they really paid for. Like I see like what they're saying, but I still haven't seen anything past September. And they're not putting in receipts for anything that they actually paid for. And like we saw yesterday, they asked for the Scott Perkey interview and didn't pay for it. They didn't pay for the redactions. Connor did. So I don't know. Monetary anything would not work for me here because that's not the case. And if that turns out to be the case, then that's going to be really disappointing. And I'll have a lot to say about that. I really will have like a whole shit ton to say. Now, WSU's lawsuit with the families, I can definitely see that maybe settling if need be because they don't want to deal with it. But I don't believe that WSU owes any money. I think that those court hearings need to hurry on. And we need to get to depositions and we need to get to the filings from the school coming out to the public. And we need to get to all of that information because that's what that lawsuit's for. That's what I want to see. So I want to see this one end up in a ruling that says that that MPD has to fix their bullshit and fix all of the horrible redactions that they've played on us. But I don't believe that WSU owes anything. I just want them all to get to court so that we can get to rulings and see the situation for as it is. Hey there, Tammy. How you doing? How you doing? Hey, Sweet Pea. Hey, Jen. How you doing? How you doing? Victoria Day. What is that? What is that? Today's Victoria Day. in Canada. It's always the penultimate Monday of May between the 18th and 24th. Queen Victoria's birthday is what it's for. I was like, well, what is it? Okay, yeah, Queen Victoria's birthday is what that is. Well, that's cool. I think it's cool. I am feeling a little bit better. I'm feeling a little awake, a little bit. 90s. Ugh. Ugh, that's true. It's going to be getting there, isn't it? To the summer times. To the summer times. Especially in a concrete city, that sucks. I would highly recommend, if you're having issues, to get one of those electric wheelchairs. That's for sure. And you move fast. That's cool. State fairs and lakes. Missouri. I've never been to Missouri. I've never been to a lot of places. Mississippi, Florida, Louisiana. Oklahoma twice to a casino, but I don't know if you can really let that count. Yeah, there's soap floats. Yeah, EWU is trying to make sure that the FOIA stuff is correct, because when it comes to this Kohberger case, and a lot of people don't know the logistics of it or like the background stuff, it's not as clear cut as people see on mainstream media. It's nothing at all like what people are portraying it on the mainstream media. Literally at all. It's a disaster. There's nothing that actually puts him in the scope of being a suspect. Literally at all. Literally at all. No, there's nothing that connects Bryan Kohberger to the scene or the victims. Even the state prosecutor said that while they switched off the plea, that there's nothing that they can even point at. Nothing they can even point at. We went to the Texas State Fair once, and that was a complete waste of money. Disneyland, Disney, whatever one's in Florida, I'm pretty sure they're all the same. The one in Florida definitely was a waste of time. Definitely a waste of money. And the state fair in Texas, when we went, was a definite waste of money. Holy shit. Like, I swear it was like $18 for a freaking lemonade. Like, y'all are out of y'all's little crackheaded ass minds. And this was like some years ago. Was it after COVID? It was after COVID. Before we moved. We've been gone for like a while. They can be really fun. I like small fairs, like the little carnivals that go to like the back end of a mall parking lot, like they used to back in the day. I like those. I like those. I like those. I like those. Yeah, we're going to watch this hearing. I have it open over here. I'm about to share the screen when it gets closer, but it's not going to start until 12:30 their time. I mean, 10:30 their time, so 12:30 our time, my time, Texas time. That's not shocking. YouTube is horrible with their notifications. And I have a fly in here that I've been trying to kill for the past few days, and it keeps evading me. So if you see me just lash out all of a sudden, because I finally got it in the crosshairs. It's going to happen. Oh, we haven't seen Boise Bella in a while. Well, I'm glad that you've heard from her. I'm glad that you've heard from her. Oh, yeah. I mean, I really try not to. I know that a lot of time when people put, they get a notification from something that they want to watch, they usually schedule stuff around it. So if I can absolutely not have to push anything or move anything, then I won't. I really try not to, because I schedule it around what I can actually deal with too. So yeah, I super try. Sometimes we have to change things. Oh, Cammy would be tripping about every damn thing that has been going on here. Oh, I've got 5,000 lists of FOIAs. My God. And I mean, I want to say I'm exaggerating, but I don't really know if I am. I don't really know if I am. Hey there, Dingy. How you doing? How you doing? Hey, Saudade. Hey, Gen X. It should be. I'm hoping that something gets actually discussed here in way of what they're actually. Yeah, I'll do it in just a sec. I'll type it in here in just a second. I just hope that they actually get into like what was paid for here, because I want to see like what kind of stuff did they purchase that was redacted. Because again, like I'm gonna go look right now one more time. I'm gonna go to YouTube and I'm gonna just go to like the search bar and I'm gonna type in like different keywords, because again, like we've been out here paying for shit. Us as a collective, regardless of whose community you claim to be in, if that's even really a thing, honestly, I don't really even know. We're all here for like the same general purpose. You, the viewers, us, the middlemen who present it to the screen, we've all collectively done our own parts here to get information out there. And we've paid thousands of dollars. Thousands of dollars. Oh, hell yeah. Go play Zelda an extra hour for me, bro. You know what's crazy? I never thought I'd ever have something in common with a freaking Kardashian. But all over Twitter for the past couple of days has been, I don't even know which one it is. I guess she's the younger one. I don't know. But one of the Kardashians is like hella obsessed with Legend of Zelda and has been talking about it nonstop for the past like week online. And I'm like, oh, she's a little normal. She's just a little normal. I need to deep clean. I wish I could do and it just be ready to go. Let's hope I don't spill for the 20th time in a week. You know, I broke my YouTube coffee cup, my black one with the monkeys on it. I gotta get a new one. Well, thank you, Sarah. It's not the family, it's the police. It's Moscow Police Department. That part. I don't want this better not become a monetary situation. That's just gonna piss me off. That part right there too. But I want to hear today what they paid for. Because if they haven't purchased anything that actually has like redactions, then I don't know what their argument is. Somebody put a I don't remember like the phrasing yesterday. Somebody put it in the chat, like how it would be like. There was just a phrase that was put in here for like, if you didn't actually purchase anything, then what are you suing them for? Because again, they said that their inquiry stopped in September of 2025. Connor paid for Scott Perry or whatever the frick, Scott Perky's interview, whatever, on like in February. So they also asked for 1112 before we did, before we tried to pay for it. And again, they can make $30,000 a day. That's freaking amazing that they've been able to even build that up. But I only mention it because we don't. Collectively in this community on YouTube, we don't at all. Not even 1% of that. So they could have gone in and they could have paid for 1112. They could have paid for interviews. They could have gone in and had all of this stuff redacted on one day's revenue and had it out there to the public on their multiple credible platforms. And we would have just been reviewing it from there. We wouldn't have had to deal with the headaches of dealing with MPD and all the lies and all the stupidity and arguing with Amber and calling Mia and telling them how freaking disgustingly organized they are and dealing with all of the bullshit back and forth. We wouldn't have had to do any of that. So yeah, I want this lawsuit to bring to light some of the bullshit that's going on. But why didn't they go through with any of their inquiries? We're not seeing them produce any receipts. We're only seeing them produce cost letters that are telling them what this stuff is going to cost. So if they didn't actually purchase anything, I don't really know what the stance is going to be here. And hopefully I'm wrong, and they end up putting receipts in to show us what they've actually paid for, because you would think the court would need to see what the redactions are, how bad the redactions are, what's the actual complaint. Well, honey, I can throw you almost 2 hours worth of footage that has no sound, for one, that they're claiming is a redaction that we know from further, review is bullshit, and no one will answer for it. I have mixed feelings about the whole thing. I just really hope that they produce things that they actually purchased. I have no idea what you're talking about. What drawings? The ones that are in the house? The ones that are in the grid, on the grid paper in the Idaho State Police records? It looks normal to me. I don't know what am I supposed to be looking at? It just looks like he's trying to map out the house. Is there something written on it? Or is this something else that somebody FOIA'd? Because I can pull those up. I mean, I don't remember exactly what freaking page they're on, but I know that we've seen them. It's on grid paper, and someone's tried to draw out the house. I don't know if that's what you're talking about. I mean, they look normal to me. I don't know. They look completely normal to me. Yeah, I'm not looking forward to that at all. The heat sucks. 23-mile-per-hour wind is crazy. We've got some crazy wind today. For the past few days, we've had some crazy wind. Just where they took us for Ariel's Make-A-Wish trip to Disney, which was a waste. Ariel regrets it. It's just a mall. It's just a freaking mall. Universal was awesome. Yeah, Sarah's is really good. That's who I went off yesterday in the live when it came to. Oh, and she said I could share the link. She commented in yesterday's video and said that I could share the link with you guys of all of the EWU documents that she's put together. I just wasn't sure because it wasn't mine to give away. But let me pull it back up, and then I'll show y'all what it looks like. And then I'll give y'all the link for it. I just wasn't sure without her permission if I could do that. But it is so freaking organized. And she's got other stuff that she does. Obviously, she's been keeping an entire timeline on the case itself. But this is the one that she put together. Copy link. So I'll put this in here for you guys. This is everything that's been going on with this situation. Everything that's been going on with this situation. EWU. But her social media and stuff is in the other video too. So you guys can go. Yeah, I have one. I'm going to get him eventually. He always messes with me. Well, see, when I try to create airflow, I get a fan. I mean, that's when they come in because I open the windows like a big old dummy. I need to get my industrial fan out of the garage. We used to have those electric ones that made that zapping sound. They look like a tennis racket. Yeah, is that the one you're talking about? Yeah, she's always the one who gets the first touch of all this stuff. First touch. Yeah, no, Zelda eats them. I haven't seen the other two do it, but Zelda will eat them. So sometimes if I'm able to actually capture one, I'll take it to her and she'll eat it like a snack. You know, Tracy? Yeah, she's funny. Yeah, it's always ridiculous. Not that we're waiting on it to start. It's got 22 more minutes. 22 more minutes. No, I have not seen that. Who is MMM? Murder Metal Mayhem? Mm-mm. Haven't seen it. Oh, guys, who wants to tell him? I can't believe you bring that boo-boo in here, Dan. Who wants to tell him? That story is not real, bro. That story is not real, bro. The person who came out with that story has already came out and admitted out of her own face that she lied. She is a serial true crime troll. She even started messing around in the Sebastian Rogers case, trying to run her mouth. The story of the person that claims to have been smoking and seeing people in the backyard is not true. Not true. We've done extensive videos about her, along with Brett Norton, who is the TikToker that was basically feeding her information while she was talking to Steve Goncalves, because y'all need to remember all this was happening at the same time. The same time that Brat was getting information from Steve, Brat was also orchestrating this bullshit with Dot. And I can say that because she admitted that she gave Dot a back-end old account for her to use to come into her lives on TikTok when she's talking about the case, to drop things in the comments, in the chat, in the live chat, to make it look like it's somebody else's idea being talked about when really it's Brat's idea, and she was having Dot put it in the chat to manipulate the chat into going the way that she wanted to. That story is not real, hun. That story is not real. I have no idea. You think they would? They act like they don't have like hardly anything. But I also don't know how, like, we have some of the messages from Snap, and then for all of Dylan's Snap messages, content's unknown. But for their for everyone else's stuff that's put in this damn timeline that's in this book that was made by the freaking cops, they have their Snap stuff. It comes to Dylan's Snap stuff, and magically all the contents are unknown. So that's shady. We have it. Christy put it out. Christy's Chaos put it out. I just haven't had the chance to watch it. It's one of the ones that we still have to review. I'm still waiting on Jack's interview. When did we pay for Jack's interview? Because we just paid over $300 for Jack Ducour's interview. The one from whatever date it is, when he talks about the phone call or gets confronted about the phone call. When did we pay for that? Dang, has it really been like a few weeks now? Let me see. Where's my phone? Did they not send me a freaking receipt for this? Because when I called, I ended up having to talk to a different chick. So I need to check my transactions. On my card to check the date. Because I talked to the other lady, Hopkins, I think is her last name. I think it's Hopkins. Hold on, it's logging me in. We got the interview from the officer on May 8th. Oh yeah, it was definitely before that. That's not it either. Why in the freaking shit are you taking so long? Extension required. Where is it? And they still haven't answered me about where Ethan's information is. And I just honestly don't have the time to go through all of those right now. It was not that far back, was it? Hold on. I don't know why this frick thing is taking forever. When did I post my screenshot? Hold on. This thing is literally like taking forever. It's like securely logging you in over and over and over and over and over. Maybe it's my VPN. It might be my VPN. All right, let's see. Go. Why is nothing working today? Okay, let's see. Moscow. April 30th. April 30th, we paid $313.51 for Jack Jacor's interview. No wonder I didn't see the damn receipt. I'm looking in May. April 30th. Okay, yeah, here's my receipt right here. When did we ask for this? Yeah, I paid the L. Hopkins lady. It's been a while. So I don't know. We should be getting it in like another week, maybe? Maybe another week? Possibly. Take this off of here now. I just don't know. See, when it comes to Jack's interview, like, you know, the new process and stuff they have now, right? So does that mean that, like, Jack has an attorney that's going to have to review the footage, or is it going to be the Goncalves' attorney that has to review the footage? Because now, like, they do their redactions, and then it has to be approved by another attorney for the family. But I've questioned when it comes to somebody who's not, like, part of the family. Like, I guess my question is, like, did the Chapins have to approve the Sigma Chi brothers interviews? And I'm going to say yes, because there would be no reason for entire, like, 2-minute segments to be missing whenever the conversation is literally just about how Stacy and Jim could afford to take care of their kids while they were in college. Like, when it comes to Ethan not having to work and, like, having money and blah, 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 whatever, they make it seem shadier than it probably is, because they're redacting the fact that the Chapins have enough money to be able to financially take care of 3 kids while they're in college, so their kids don't have to worry about money. That is such a damn flex. Even to be able to handle that kind of thing as a parent with one kid in college and knowing that they don't have to work, they can focus on their studies, they're going to have money for whatever they need to. That is such a damn flex. So I don't know, like, why they would choose to have that information, like, blocked out. I find it ridiculous. But it's whole paragraphs of words. So when it comes to Jack DeCour's interview, who's the one who goes and checks it? Who checks Jack DeCour's interview to see if it's how the Goncalveses want it for the information that's going to be talked about their kid? Because you know it's going to be a lot about Kaylee. So who's approving that? It's got to be them. It's got to be Shannon or whoever. Who knows? We still have to get the other one. This one is, I think, from, I'm not even going to try to quote the damn dates. I just know that it's the second interview, which I did not want to do it this way. I did not want to do it out of order. I just didn't want to pay for both of them at one time. I didn't want to hand them over. God, this one was 300 and something. The other one is like 180. I didn't want to hand them all that freaking money. Do one at a time. Kiss my ass. Y'all suck. But this one was the most important one, in my opinion, because it talks about the phone call. But my thing is, they're going to redact it. I bet you anything they're going to redact a bunch of the information about that 17-minute phone call. Because the Goncalveses are going to fucking have the lawyer do it. How much you want to bet? How much you want to bet? So we probably just paid $300 for something very specific to hear in his interview, and we're not going to hear it. The same way that we paid $1,500 practically for the 11/12 footage, and the most important sections are muted. So there's that. Now, I know that Birdie apparently got the run from 12/22, and that's supposed to come out tonight. I'm still doing my live about the book chapter. We've got to keep up, so I'll just look at that later. Plus, it's just pain driving. We know what that car looks like. I'm more interested in the fact that the screen snips that he's posting are color, and it's around like 10 o'clock at night when it's nice and dark outside. Now, but we do know that that camera will go color if it does sense certain motions. We saw it when people were coming up on the deck. So if that damn camera is actually triggering motion as that car is crossing, like turning the corner, I'm going to be real mad. Because the whole time, it never changed color out of 12 freaking hours of footage. It never went color for a car passing by. It only ever went color for someone being up on the porch. Interesting just is not really the word I would use, but yeah. I don't know. Yeah, it doesn't. I mean, I don't know. No. See, that's the whole thing about that damn name. That's the thing about that damn name. It was a girl that went by, BK Norton. You're right on you're right on that. But BK Norton and then Brad Norton are not the same freaking girl. And I still have to do that video because a lot of people get confused because of the Norton part. But no, BK Norton was the TA. She's the one who started filing all the stuff against Kohberger because they got into an argument and he asked her to go out for coffee and she thought that it was like him hitting on her and not respecting the fact she's a lesbian. Okay, that's literally her argument. It's in the damn reports. And so she felt like he was overstepping a boundary because he knew that she didn't like dudes when he asked her for coffee. Lo and behold, turns out home dude asked everybody to go out for coffee. He just likes coffee, apparently. Everybody gets coffee. And so she started filing reports and being all crazy. But it's not the same person that Steve Goncalves was talking to. Not the same person that he was talking to. The Norton person he was speaking to is a TikToker who should have never gotten involved in the situation because she made everything worse, in my opinion. But that's just my opinion. You know, just my opinion. It's not just going off the grid. He's still out here trying to say that Kaylee didn't die till December 10th. So you're trying to make me believe that we didn't see a single body get taken out of that house. So we didn't see a single ambulance come up and take nobody away. And that her face was so disgustingly destroyed that it didn't even look human to people. But she survived until December the 10th. How? How did she magically survive if we didn't see an ambulance and any medical assistance show up? And to this day, he's still pushing it. He even brought it up, I think, during the Chris Whitcomb interview. What's wrong with you? What's wrong with you? That's insane. That's insane. That was my introduction to Birdie. So when people wonder why I don't like him, that's why. I was gung-ho about it. There was a whole other person coming in from TikTok that was making a wave, that seemed to be paying attention. It was asking all the right questions. But the first time I went over there, that was the conversation. And I instantly looked at my people and I'm like, are y'all crazy? Why in the hell would you send me over there? Are you insane? Are you crazy? You crazy? A little bit crazy? And yes, if he didn't still push that, then maybe I could care a little. But he literally just brought it up to Chris Whitcomb in the interview. Didn't produce the record, just straight up said it in the interview. Like, what are you doing? What are you doing? Yeah, I can't. That was my first introduction to him. My first introduction to Birdie was December 10th is when Kaylee died. You are out of your freaking mind. You are out of your freaking mind. I want to get this page set up real quick so that I can get this open. Is it going to go? Okay. Am I going to have to constantly do that? Or is it better if I do it like that? Yeah, I already said I was going to appeal. I have until June 19th. I don't know how far it's going to go. Like I've tried to get a hold of Dollinger several times and he's not responding. And the city attorney is no help. She's a freaking moron. She can't answer anything about protocol or who touches what or when or where, or any freaking thing else. And every time I've tried to get any more answers, I'm just told, oh, you need to talk to Chief Dollinger. You need to talk to Chief Dollinger, blah, 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 blah. Well, Home Dude doesn't answer emails. For one. Then, when you try to get a response again from him, he's miraculously out of the office. And here it's been a whole nother, 2 weeks practically since I sent that email. And he ain't said a damn thing. And I've sent him everything. I've sent him the reports, the timeline. I just want answers. You, Mr. Chief, are the one who took over from Fry. So you should know where this information is. If this really was, and he's touched it too. Dollinger has had his hands on 1112. So, I could say it's kind of pointless to even talk to this guy because he's just the chief. He's just the supervisor. We know how supervisors normally go. But he wasn't at the time. And he touched 1112 too. There's a report with his name on it when it comes to 1112. On it somewhere. Andrew Fox touched it. Tim Smaldridge touched it. Blaker even had a portions of it. People went out and took the camera back out to the house. Payne handled it. So many freaking people touched the 1112 footage. But Mallory still couldn't even get it in the possession of the police until the 19th of November. So again, the owners were going around and giving everybody that wanted it access with the password, including the Goncalveses. And if the Goncalveses have it, don't you think the freaking Chapins had it? Like, come on. Jack just happened to be friends with the girl that lived there, according to Steve. And Steve makes it sound as if they had that footage that night with the way that he said it to Brat. And we know that he had it regardless. We've known since Linda Lane that he's had 1112. Because he used the 156 screenshot from Eric Gower turning into Queen to drop the girls off as proof to Brett Norton that the Linda Lane stuff was wrong. Is that the guy that works with custody queens? I don't have any issue with Ron. The little personal little tiff thing that I've got is with Kristen, whichever one she is. But yeah, I don't have an issue with Ron. Yeah, we have until the 19th. We have until the 19th. I just don't know how to work the appeal if I'm not getting a response from them. Because at this point, all of them, all the way to the city attorney, has told me that I'm wrong in thinking that there's sound. But I'm not. And this is coming from people who don't touch the evidence, who don't read the reports, who don't know shit other than what they're handed. And what they're handed is not an answer to evidence and what it says. What they're handed in that department is, are these redactions right? Are we blocking enough information? That's the only thing they freaking know. There's like, even ISP touched it. Like, people with the Idaho State Police messed with 1112. We know damn well that the freaking feds had 1112 too. So there's no telling. There's probably a good 20 different freaking copies of this footage. Maybe not of like all the way across the board of this footage, but there's definitely at least 20 copies of the time frame of the crime that they're giving us. That's for sure. That's for sure. They have the 5-minute segments, which is like what, like 1,700 or 1,400 different segments, because it does this weird thing in 5-minute intervals. So they have like, what was it? 1,464 is the number that my brain wants to say. And then that got condensed down and put together into 17 different sections, is what the report says. I don't know how the hell I remember those numbers, but that's what it says. Probably because we just looked at it yesterday. Or I just looked at it yesterday. So yeah. So many freaking people touched it. And actually, this December 22nd piece that Birdie's going to have out tonight, I had wanted to get this a while back. As soon as Amber told me about it, because I didn't know when she was telling me on the phone that we had a report about this already, because I had asked her for the entirety of 1112, and it's from 12:55 a.m. on the 13th to like the 17th at some time. I think it's on the 17th, is what they like had as the entirety of the 1112 footage. And then December 22nd is what she had told me on the phone. And we had those reports, but at the time it just didn't really like hit me in the head. And then when I came out live and told you guys what she said, y'all told me in the chat, oh, we have that report. That's when they went out there, blah, 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 whatever. And we looked it up, and yeah, that's when they went back out there to like put the camera back. Be careful with that one, Din. All I'm going to say about other channels is to make sure that you care about where you're getting your information from. Because I care about where I get my information from. That's why I don't listen to a lot of people. You really have to do research into the people that you get your information from. For real, for real. For real. Now, I will say, there's a guy that I so far really have not had any issues with the way that he's told stories. He's not a deep diver. He's a storyteller. His name is Ty Knotts. He has red hair, curly red hair. I don't know what their story is. But I know that for one, I like the way he comes out and tells stories. I like the way that he tells the case. When he told Kylie's story, I was actually like impressed because he was really like out there with the questions and making sure that people knew the discrepancies and the issues with Kylie's case. And he's actually done like more than one video on Kylie's case, which I like too, because he's kind of keeping it out there. He sounds like he came from a town like Moscow, because sometimes he'll make comments, like I'll make comments about my town and how it's ran by Shriner, And then he'll make comments sometimes about how him and his wife had to like escape the small town they were in because of this kind of mentality and blah 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 whatever. So I feel like he kind of gets it. I haven't come across a video of his that I felt like he had anything wrong. At least, I mean, in the cases that I know of, he seems to be pretty factual. But I don't really listen to like a lot of storyteller channels. Like I like Rotten Mango because of how detailed she gets, and I know that she's got a big team that helps her. I know she's gotten some things wrong, and I know people have talked about it, but I feel like she's really, really detailed. I don't like how sometimes she starts out her videos with things that don't make no sense. I mean, she kind of makes them make sense later, but at first I'm very lost. Very lost. But I like her. I'm trying to think of anybody else I actually like listen to sometimes. Anytime Conspiracy posts something, I'm listening to it. I mean, it's more like the drama side of stuff, tea part of stuff. But I like Conspiracy. She tries to be like super factual too. Let me think who else that I haven't mentioned. I mean, I just don't really have a lot of time to sit around and listen to people. It's not ready yet. Oh, there it goes.
James. And then there was a motion to continue that's been filed by the city. Mr. Jones, Ms. Brereton filed that motion to continue. The oral argument on the substantive issue of the public records request. Declaration of Ms. Batista was filed in support of that motion to continue. And then court has also reviewed Ms. Kennedy's objection. Before we proceed with oral argument, I would note here for the record that we do not have a court reporter today. This matter is being recorded through the FTR system, but due to a shortage in court reporters in our district, our court reporters are currently in other courtrooms and unavailable for this particular proceeding. So I do need to ask Ms. Kennedy, on behalf of the plaintiff in this matter, are you agreeable to waiving the requirement of the court reporter here today?
We are, Your Honor. Thank you.
And then Mr. Jones or Ms. Brereton, I'm uncertain which one of you will be arguing today, or maybe both.
I will be doing most of the argument today, Your Honor. And with respect to the limited question of the court reporter, we have no objection to that.
Okay. Mr. James, on behalf of the interveners, are you agreeable to waiving the requirement of the court reporter?
We are agreeable, Your Honor. Thank you.
All right. So based upon that, that requirement will be waived pursuant to the rules for this proceeding. We will go ahead then and take up the first issue, which is the motion to continue that's been filed by the city. So Mr. Jones, if you wish to proceed on that matter.
Thank you, Judge. Your Honor, what we're asking the court to essentially do today is address the procedural issue of the petitioner's standing and capacity to bring this lawsuit, but however, to not address the substantive issues. And if the court finds that the petitioner does have essentially standing to bring this lawsuit, then we would ask that the court continue the substantive issues for an opportunity to fully brief this. This is largely a judicial economy and interest of justice argument, in the sense that this is essentially a 12B6 motion, in that no matter what the petitioner, no matter the merits of the case, they cannot prevail because they haven't registered to do business within the state, and so they don't have access to the courts. And it shouldn't be the city's obligation to incur the costs of litigation and so on if the petitioner cannot prevail on the arguments requested. And so with that, I think that it's in the interest of justice for the court to grant this continuance in this fashion. And then I think most importantly, this is a matter of significant consequence. And I think that the court and the public deserve a fully complete record. This bell can't be unrung. And so once the city does disclose these records, these records are out there. And so I think that it does have a certain amount of interest to the public and the city and the petitioner to fully brief this and fully allow the parties to develop their arguments. And so with that, Judge, we're asking the court to structure its decision in that fashion.
Mr. Jones, I do have a question. I mean, understanding the city's argument with regard to this threshold inquiry, even if the court were to find that EWU was transacting business in the state of Idaho such that it should be registered as a business with Secretary of State's office in the state of Idaho, it has done so now, given the city's argument. So does that not make the issue moot at this point in time? What more would you be requesting as far as any kind of, I guess, court ruling or remedy on that issue?
So with respect to that, Your Honor, we don't feel that that necessarily cures the position of the petitioner by registering. At the risk of getting into that particular argument, it's our position. First of all, I would object to that declaration on May 1st as the fact that it's hearsay. The rules of evidence apply to this hearing. I can get into that objection a little bit more. And so I'm not sure that for the purposes that that's properly before the court. And then in any event, the case that the petitioner cites to essentially argue that they can cure the defect and register anytime prior to judgment, that's that analyzes a different statute. It's a 1968 case, and it considers contracts. And so essentially the question that was before the court in that case, and that's Twin Harbors Lumber versus Carico. The question that was before the court in that case was, should a contract be voided? And so we aren't necessarily conceding the fact that because they've registered, they now have standing. However, that does, for the purposes of the motion to continue, that does materially change the posture of it as well. And so because now they are registered. And so that would be our position there.
Well, I guess I'm trying to understand then, because your briefing on this issue, well, let me back up. So the city had an opportunity. Obviously, there's a couple of things that are going on. So first of all, court set the underlying issue on the petitions for public records request for this particular argument. In that period of time, when the court set the briefing schedule, the city elected to, in its response, file a response which essentially could have been filed as a motion to dismiss in a sense, but on this particular issue, and not respond to the substantive argument regarding the public records issue. And so I don't have any information from the city on that, which I understand your argument to be, you want the hearing to be bifurcated. But what I'm trying to figure out is, in your response, in the city's response, when it took the position of that EWU needed to be filed, because I'm reading it as there, you argue, the city argues, EWU is a foreign filing entity doing business in the state of Idaho, and so it must be registered with the Secretary of State's office to maintain an action in the court. Is that right, Mr. Jones?
Yes, Judge.
Okay. So they're now registered, or even if they are registered, well, let me ask, do you disagree with that?
I mean, for the purposes of the evidence, like the hearing, we're going to object to the introduction of that evidence, but I don't disagree with the fact that it appears that they've been properly registered. I want to just use my words carefully there. I'm not going to challenge that necessarily.
Okay. So would the remedy be, so let's just say the court were to find that they were a foreign entity doing business in the state and they weren't registered. If that were the court's findings, then the city would be asking that this be dismissed. Right?
Correct.
Okay. But then my question is, so if that were the case and the court were to order it to be dismissed and then they do register, which we believe, it appears they have. So if setting aside the rules of evidence, I understand. So then they could refile, right? Impose
Correct.
it. And so we would be back in the same position of arguing the substantive merits. Is that right?
Yes, Your Honor. And I guess in a nutshell, I mean, if the court finds that that registering cures the defect for the purposes of this petition, then continuing it would satisfy the interest of justice, because then the city would take the opportunity to respond to the merits of it. Now, a couple of things that would change. Should the court dismiss the petition today, they would have to refile a public records request. And the statute changed. I don't know how much that's going to impact the petition here, but we will be analyzing a slightly different statute come July 1st. So a couple of things would have to happen. They would have to either rush the petition in to get it under the current statute, or we'd be analyzing a different statute. Again, I'm not sure how much that would impact this analysis, but that's something worth keeping in mind. But in a nutshell, Your Honor, correct. We would just be right back here after they filed another petition, or assuming the city denied it again.
Okay. And so then my other question is that why didn't the city, we're talking about, and you made reference to this, and of course the court believes the same thing, that it's important in this particular situation to have full, complete, accurate positions on everybody's side in order to make a proper decision here. Why didn't the city elect to respond substantively by saying, essentially, in the event the court were to find that they do have standing or could sue, then we would argue this, and this?
Well, I think first and foremost, the petitions for public records are a little bit complicated because the rules of evidence don't apply. So we're sort of just winging it as far as procedurally. Sorry, I said rules of evidence. I meant the rules of civil procedure. The rules of civil procedure don't apply. So we're just kind of winging it procedurally, in the sense that, we can't just file a 12b6 motion. So we took the position that they don't have standing, and we stand by that, in the sense that at the time we filed our response, they weren't registered. They registered to do business afterward, which again changes the position. But the city we didn't feel it was appropriate for the city to incur the resources where to defend this action, where no matter what the court decided substantively, the petitioner didn't have standing to sue in the first place, or access to the courts. And so it seemed to be like the most judicially economic course of action.
Okay. Thank you, Mr. Jones. All right. Ms. Kennedy, a response.
Thank you, Your Honor. We do object to the hearing being continued today. The Public Records Act contemplates prompt judicial review, and we did agree to extend the briefing out and extend the hearing out a few months in this case, to give all parties time to put their best foot forward. And the city did have ample time to brief the merits of its claimed exemptions, and it should have known what its exemptions were at the time that it actually made the denials. And so it's really had plenty of time to support its exemptions and its denials. And a continuance here would essentially reward their delay, and it would undermine the Public Records Act's goals of transparency and prompt resolution of public records disputes. But going into their actual capacity argument, EWU was just simply not required to register in Idaho. It's a national media company, and it's engaged in interstate journalism. It has no Idaho offices, no Idaho employees, no localized Idaho operations. It requests Idaho public records. It reports on matters of public concern in Idaho, certainly, but that doesn't constitute doing business. Otherwise, every out-of-state journalist or media company would need to register before requesting records or enforcing its rights under the Public Records Act. And that interpretation would burden interstate journalism, it would chill First Amendment activity, and it would create barriers to access that are just simply not found in the Public Records Act. Most media companies are owned by national organizations nowadays. Even our local papers and broadcast news are owned by national organizations. And so if we had some rule that every time you report on Idaho activities or you request Idaho records that you have to register to do business here, that would really chill First Amendment activity. And the Public Records Act, it focuses on the records, not the requester. The requester's identity and motive are supposed to be irrelevant. And the city has really focused on EWU's identity and its business model, and that simply is improper and irrelevant to the disclosure analysis. So requiring some kind of registration requirement, it would impose a subjective analysis, and it would allow the city to look into who's requesting these records and why are they registered, or are they registered to do business here? And that simply would be another barrier that's not in the Idaho Public Records Act. But I think the court is correct that any registration issue is now moot. EWU strongly objects to having to register to do business in Idaho, but it has done so because it thinks this case is important and that the merits need to be heard by this court. And so it did not want to lose its case because of that. So any defect has now been cured. But the city's other reason for delay is that FBI letter. And we can talk about the substantive issues related to that later. But the relevant inquiry is the basis for the denial at the time of the denial. And here, this FBI letter was obtained months after litigation began. And under Wade v. Taylor, the city can't retroactively supplement its denial grounds through a post-litigation FBI letter. It still identifies no specific federal statute or regulation, and it really just isn't an exemption under the Public Records Act. It also only addresses FBI-generated records. It says nothing of these supposed Pennsylvania records or any of the other issues that are listed in our petition. And the city we understand that they've had a ton of public records requests, but on these particular issues, which are fairly finite and well-defined, they have had 10 months to identify the applicable federal law, and they've still failed to do so. So we don't believe a continuance will help that and will change things. I do want to say too, this allegation that Ms. James, that her declaration is hearsay, I would have to look at the rules of evidence, but my recollection is that public records or public documents are not hearsay. This is an official document from the state of Idaho. And Ms. James is simply authenticating it because she was the party at EWU Media that actually requested that we go ahead and get this registered and helped us do that. And so we don't believe that document is hearsay, and we think that the court can consider it in deciding that this issue has been mooted. So to summarize, we believe that the equities favor proceeding today. There is a strong public interest in timely disclosure. The Public Records Act is intended to ensure timely public access to government records, especially in matters of extraordinary public importance like this case. And the city has already repeatedly delayed this issue and hasn't really provided us a basis for withholding these documents. And we don't think that would change with the continuance. So we believe the hearing should proceed today. Thank you, Your Honor.
Ms. Kennedy, understanding, that the public records request, the act, and obviously the need to hold a hearing within a relatively short period of time. Other than that argument, which is still substantial, what would be the prejudice to EWU or EWU, I guess is now what I'm understanding. It's probably better pronounced as from your representation. So EWU, what would be the prejudice if the court were to continue the merits hearing for just a couple short weeks?
Your Honor, I understand the court's question. I can't identify a specific prejudice that would go to EWU itself. But I would say I think the public is prejudiced whenever the Public Records Act is not timely complied with and these issues aren't dealt with in a timely manner. And so, but apart from that sort of general prejudice to the public and the lack of transparency, I can't identify for you a specific prejudice that would go to EWU specifically.
All right, thank you. Mr. James, do you wish to weigh in on this particular issue, the motion to continue
I do, Your Honor. Thank you for the opportunity. Leander James, please the court. I'm here on behalf of the Chapins and Karen Laramie. I think both parties agree, as listening carefully, they both agree that this is an important issue and an important case. And I want to put a fine point on that with pointing out that the Idaho legislature has now amended the statute based upon this court's prior ruling in the case of Laramie et al. V. City of Moscow, Lake County case number CV 29-250755, the permanent injunction case. And it is an important issue and it should be fully briefed and argued. I will add to it that I will report to the court that recently, within the past week, I've been contacted by an attorney in the state of Nevada working on behalf of a governmental entity that is going to apparently petition the Nevada courts to amend their public record laws based upon this court's prior injunction ruling. And I suspect that attorney probably is listening to me right now. And I know that attorney is monitoring this case. And I've had inquiry with others, including media, who are monitoring this case closely. So I want to address what I think are the most meritorious, as I see, argument that Mr. Jones made, and that is that he needs a little more time to reassess the city's position and to fully brief the case. I think, you know, if the balance is tipped in his favor, I think it's partly tipped because of the importance of the case that both parties agreed to, and the interests can be affected beyond this case, including interests in other states. Another point that was made by Ms. Kennedy about the public interest. And her argument was that the public, anytime there's delay, there's some prejudice to the public. And I think that's somewhat true, that there would be, you know, a modest delay or could cause some modest prejudice in the sense that the public might want to know what information would be disclosed here. But there's another aspect to the public interest that the court, I think, should consider. And that is that we get it right, that we get the answer here right. The court took a great deal of time and effort and energy to analyze the permanent injunction case and to get it right. And I think we should do that here. And for that reason, I don't oppose the city's, I do not oppose the city's request for a short continuance. I think it's merited for the reasons I've said. I think it's important we get this right. I am interested to see what their ultimate position is on the merits. I do not know what it is right now. And that's concerning to me because it's going to affect my clients, I think. I'm not sure how broadly or narrowly they will interpret the permanent injunction that is of primary interest to my clients. So for those reasons, Your Honor, I respectfully request the court grant a short continuance. I don't think Mr. Jones has been unreasonable. I think he just needs a little more time. Thank you, Your Honor.
All right, thank you, Mr. James. Mr. Jones, do you wish to make any reply argument on the motion to continue?
No, Your Honor. I'll submit and stand for questions.
Admittedly, I've had a lot of time, or I had time to obviously to review the briefing here, and coming into the hearing, I have had a little bit of a different position than I think I have right now, given what I've heard as far as argument. candidly, because of this particular issue, we talk about kind of, I don't know, the gravity of it and what kind of case it is or the implications that it would have to have these records in the public. The bottom line is that, as EWU argues, and I think all the parties agree, is the Public Records Act provides access to records for the public, so that we can ensure that individuals' First Amendment right to see, hear, and have or obtain certain things with regard to certain matters is achieved. And that is the framework for which individuals can seek to obtain those records. Really, the court is only brought into that when there becomes a particular issue. And it's really on a very limited or narrow scope as far as determining, what should be disclosed in compliance with that law. Taking all of that into account, I, though, as the judge presiding over the matter, and now that it has come before the court, do feel that I'm at a bit of a disadvantage, if you will, if I do not have all of the information necessary to make an informed decision. Quite candidly, it was I understand the city's argument, the position that it took. It was a little surprising initially to not see kind of the follow-up substantive argument, to be prepared to proceed on that here today, because I think it leaves unanswered a lot of questions that, quite frankly, I think EWU is seeking, which is, what is the basis for the denial itself? What is the legal basis for the denial? And from the affidavits or the declarations that have been filed, specifically the declaration of Ms. James, that filed on March 30th, within that contains the city's responses as far to those public records requests, and kind of generally cites to reasons for denying the request. But that's really all the court has as far as that substantive part. On top of that, according to, and I think it's the declaration of, again, Ms. James, but it's the records request specifically from September 15th of 2025. I believe that is the most recent or most specific request that's been initiated to the city as far as the specific records that are being requested. But I don't have anything else to go by necessarily. So what I'm getting at is that, generally speaking, there's an argument here that, aside from the argument to continue about whether they're standing or not, there is an argument that's being made that the city's using Pennsylvania law, federal law, or other things to not disclose certain records. I don't even know which particular records we're talking about, and what that entails. So even if I were to go that direction of say we need to have substantive argument today, I would be happy to hear that argument, but I think I need more information anyways from the parties before we actually proceed to figuring out, quite frankly, what you want me to figure out, which is, what information is it the whole case file in its entirety And if it is, what does that entail? And what specifically can the city point to by saying, yes, that document was specifically, you've requested that specific document. It was created by, the FBI. Our argument is that we're not the custodian. I don't know, or it was created by Pennsylvania. Here's what it is. They're the custodian, whatever the city's argument might be. On top of that, I think I need from, like I said, I'm referring to or looking at what I believe to be the last records request again would be September 15th. I can see within that some of the city's response as far as what that entails. But I think I would also need information from Ms. Kennedy about what has EWU already obtained and what more specifically were they seeking that they did not get. And maybe that has been provided to by way of the records request. Maybe Mr. Jones and Ms. Burton are more aware of that as far as Ms. Kennedy, whether that's been, provided to them and they can specifically respond to that in a way. But I guess for my purpose in ruling on it, I'm feeling a little bit in the dark on that portion as far as what I'm ruling on. If there's a request to make a blanket ruling that the city, anything within the city's possession, that they are custodian of must be released. I think that's a different inquiry than, more specifically as to the records, each particular record. Now, I say all that because I agree that when I came into this hearing, quite frankly, I was inclined to say, no, we're not continuing it. Because I think the city had an opportunity to respond and instead chose to take a different approach and argue the issue of standing. Now that we are in this hearing and I've heard argument here, more specifically, Mr. Jones reference to the procedural posture is a little different. The rules of, civil procedure as application to this is different. And so as far as any arguments or motions, 12B6 or otherwise to dismiss, this was the state's or the city's option or choice in doing so, which is a little different than what's provided under the rules of civil procedure. On top of that, I think that there's also been more clarity as far as what the issue raised is. Mr. Jones saying the implications of if the court were to find that even if the remedy were cured or not, but if the court were to find that EWU was required to register and it should have been, should be dismissed, even though I think judicial economy may say otherwise, but regardless, even if it were to be should be dismissed, that may change the setup for what EWU is requesting. For example, do they have to then, based upon the timing of that, would have to refile a public records request, and what would that look like? And may some of these issues be cured in the meantime? I don't know. It would change the posture of the case. Certainly not suggesting that I have a decision on either one of those things, but that does change, I think, the way in which the court was initially looking at it, because by way of the briefing, it would seem to suggest that the issue was cured by the filing. And I don't, having heard from Ms. Kenny, which is why I asked, is appreciating the argument that there may be prejudice to the public. I don't know that there is, given the time that has lapsed since the records request, but also, setting that we've set it on a timely hearing, the parties agreed to it setting as far as that hearing is concerned. There doesn't appear to be a significant prejudice to EWU to continue the matter, understanding they've been waiting for these records for a period of time. Not suggesting there isn't any prejudice, but perhaps not so significant that a short continuance would be unnecessary. So I believe that based upon what I've heard here now in court, what I am going to do is I am going to grant a short continuance of the substantive argument. What I am going to do is consider the issue with regard to the standing, the foreign entity argument fully submitted. I will issue a decision on that. Depending on that decision, we will set the matter for further hearing. We will notify the parties. What I will do is I will set it for further hearing at this point, give you a date, and then in the event that that were to change, for example, if the court does find that the petition should be dismissed, then obviously that next hearing date would be vacated. But on an alternative, the court were to find that the issue's been cured, should continue, then we will proceed with the full argument. And I'm going to set that for is counsel available on June? Let me just double check. June 8th. Okay, June 8th at 9:00 a.m.
I'm available.
I have a meeting if that I can probably reschedule. But if there's other unavailability, I'll jump on that bandwagon. But if I'm the only one that's unavailable, I'd like to move it.
I am available on June 8th, Your Honor.
I have no conflicts on June 8th.
Okay. So Mr. Jones, you are saying, I didn't understand. You're saying you're okay or you're not?
I'll make it work. Since everybody else has no conflicts, I'll make it work.
Okay. June 8th at 9:00 a.m. That's Pacific time. And so I'm going to ask that, I believe it's this, Miss Kennedy, do you wish to, couple things, do you wish to advance further argument with regard to your underlying petition? Will you wish to submit any further briefing? Not required, but I just want the city to respond to your most current briefing.
I think we would want the opportunity to do a reply to whatever
Okay.
the city filed, like a supplemental reply. And I also, listening to the court's comments, I had maybe an idea on how we could get some clarity on what documents we're talking about. I think the court theoretically could just make a ruling that as a matter of law, Pennsylvania law doesn't apply, or there's no federal law, for example. But if the court is inclined to do more of a document by document analysis, and if that would allow for clarity, the federal courts do something called a Vaughn Index is the name of the case. And that occurs in FOIA cases. And it basically is like a privilege log from the agency, which lists out all the responsive documents and what exemptions are claiming. And for example, in this case, we know that there was an interrogation of Bryan Kohberger that was done in Pennsylvania, but Brett Payne from Moscow flew out there with the FBI. And so the interrogation was conducted by FBI, Idaho, and Pennsylvania. And we don't understand if that's being claimed as a Pennsylvania document or an FBI document or both. Of course, it seems to us it should be an Idaho document. But I wonder if some kind of log like that from the city would be helpful for the court and the parties. We, I think, would have preferred just kind of a a blanket legal ruling that these exemptions don't apply, but to the extent the court wants to do more of a document by document analysis, that would be my suggestion.
All right. And I referenced, I think, the September 15th letter. Is that the most recent?
I would say for the court to look at kind of more of the specifics of the parties' dispute, I would point the court to the August 25th denial letter, and then the that September 15th denial letter. I think those are the most salient in terms of what records we're talking about, but it is confusing and it's a little vague to me on what the city is withholding.
Okay.
May I address the court?
Yes.
Your Honor, I think there's merit in the suggestion that the city and EWU creates a type of, akin to a privilege log of what documents specifically we're talking about here. For my purposes, because I may not have an interest in a lot of these documents. The graphic ones, yeah, I'm going to have an interest in them. So, if there was a list, I think it's incumbent upon the requester to identify what they're requesting first, and then, the city to identify what they're not producing. And then I don't know if the parties are agreeable to this, but if they could come up with a list, it would be most helpful along the lines Ms. Kennedy is suggesting, with a brief description of what is in the document, so we know what we're arguing over. Otherwise, I'm with the court on this. I'm a little bit in the dark about not only what arguments the city has, I need that, but I'm also in the dark as to what specific documents are we talking about and what is in them.
Right. Thank you. Mr. Jones, what's the city's position on essentially a log of?
Your Honor, that makes a certain amount of sense, and I'm sure that would illuminate things for the court. I'm not opposed to doing that. However, I would respectfully submit that 2 weeks is pretty short window to perform a privilege log in addition to the response brief. And I understand that beggars can't be choosers, but
I guess my thought was that maybe I shouldn't make assumptions. I was thinking that a log of some sort, or has probably already been created somewhere of all the things that are there, given the length of time that this case has been, not this particular case, but criminal matter had been ongoing. But maybe you need to consult with, your client about that, Mr. Jones, and determine, how long something like that might take.
yes, Judge.
Okay.
If I could say, Your Honor, I do have some sympathy for the city here. I've been notified every time they get a public request, a records request now, and there have been an awful lot. I think they're limited in their resources and they're struggling to keep up. So that may have impacted their ability to do a log at this point. I don't know.
Well, you can see the court pondering. I want to make sure that in the interest of that we only have to do this one time, I guess is what I'm trying to get to. I do think that it's incumbent upon the requester to identify what they want, which is why I was trying to, again, get to what was the most specific request that we had that was actually denied, that we need to address. And so I think there are, certain things within that list that were specifically noted, at least from the September 15th letter. It was like a supplemental, and there was specific things listed within that. There was only about, I don't know, it didn't seem like there was too many documents within that needed to be, that would take too long to address. I do know, as far as the case itself, of course, there's probably a lot to say the least. So I don't know, again, Miss Kennedy, I'm not sure what EWU has obtained or what they're still waiting for. And maybe they've gotten a bulk of that, but haven't gotten just these specific things.
Would it be helpful to provide something to the court? I mean, I think some of it is hard because we don't know what the city has. So we're kind of guessing. We're based, like the interrogation we know about because of a supplemental police report that we did get, but there could be other documents out there that we just have no idea even exist. But I could put something together for the court that lists our requests and what we've received and what is missing, or just even what's missing, or what we believe is missing. But I think the city still needs to identify that if there are any documents that were responsive to our requests that they withheld, I think that they have the burden to prove an exemption for those and maybe tell us what those are as well.
Mr. Jones, what's the position on that?
I mean, I guess the city's position would be that we're not objectionable to a log. And so the situation that I'm I can't answer without speaking to the city first is how much of a burden that will be on the city to produce a log. And so I don't know if you want us to go into a breakout room or if you want just to, I mean, we can get it done. So if you want to just set a hearing, we'll get it done. But I don't want to overburden the city staff.
Okay. Well, let's move, let's see. Could the city provide, I think let's move the hearing out so we can make sure we do this right. So can the city provide the log by June 22nd?
Yes, Judge.
Okay. And then I will have Mr. Jones, I'll have the city's response to the petition will be due, how about July 10th?
Yes, Judge.
Ms. Kennedy, can you have EWU's response or reply, I guess, by July 24th? 2 weeks? Do you need more time?
An additional week actually might be helpful. That's okay with the court.
Yeah, July 31st.
That would be great.
Okay. Mr. James, as the intervener, when would you like to have, I think it makes sense, you wanted to have the city's response.
Yeah, honestly, it'd be good to have both the response and the reply. I don't need a lot of time. It'd be nice to know what the reply is, but if the court, but probably the proper thing to do is just give me at least couple of weeks from the city's due date. When was that?
The 10th.
10th. Yeah. So, and I'm sure Ms. Kennedy would say, well, I want to hear what he has to say before I reply, and that's probably reasonable. So what if my brief is due the 24th?
Okay, I think that works. All right, and then we can have a hearing. Okay, what does August 10th at 9 o'clock look like?
I'm available then. Hopefully my client is too. She's listening. Can nod.
Yes.
I'm available, Your Honor.
I have no conflicts with that day.
Mr. Jones has something, I can tell.
I'm going to make a record of it. I have a homicide trial that is not going to go to trial at that time unless something very bad ends up happening, but it hasn't been continued yet. So, but it's going to get continued. So I propose we schedule the hearing, and I will know in early June because that's when the pretrial conference is. But if it doesn't get continued, I just bring that to the court's attention and speak with Ms. Brierton about it.
Okay. So August 10th at 9 o'clock a.m. is when we'll have substantive argument on the issue. And, I'm just going to go back to like where I started here this morning this is not where I anticipated that we would be, but I do think that sometimes this is the way things happen in the sense of making sure that we have all the information. I think, quite frankly, for myself, but for the party's sake, so that we can figure out exactly what we're talking about and to do it right, hopefully, the first time instead of having to keep coming back to court is my hope. So I know this is going to cause a little bit of delay in the records and getting those, but hopefully even in the log itself, I'm hoping that once that's created and even provided to Ms. Kennedy, that might be even a talking point for you all to say, well, are there things that we haven't had that we can have, or what it might be? I don't know. So I think it will help us move things forward actually better going forward than it would have. So I appreciate everyone's patience, as we navigate through this. So is there anything else to take up for today, Ms. Kennedy?
No, thank you, Your Honor. We appreciate your time.
Anything else, Mr. Jones?
Judge, if I could just ask Ms. Batista if she feels that her presence is necessary on that August 10th hearing. Yeah, I believe she wants to be present and she's unavailable on August 10th.
Okay.
And I hate to do that at this point.
Can I ask, is it for the full week? You can just nod. Okay. What about Wednesday, August 5th?
I have no conflict, Your Honor.
I can make it work, Your Honor.
That would work for me and hopefully Ms. James too. Yes.
That works for me as well.
Ms. Batista, does that work? Okay. All right. So we're going to Wednesday, August 5th at 9 o'clock a.m. Yes, and that'll be live streamed for, I think there's maybe some folks who are listening in, so we'll make sure that that is live streamed again. Anything else then, Mr. Jones, on your side?
No, thank you, Judge.
Okay. Anything else, Mr. James?
No, thank you for your attention to the matter, Your Honor.
Yes. All right. Thank you. We will be in recess for today.
Thank you.
How so stupid. How stupid. How stupid. I told y'all they were going to have to produce what they've obtained and show the redactions that they're complaining about. They have to produce interviews that have pieces missing. They have to produce footage that has blurred stuff all over it. They have to produce documentation that has redactions. They can't just go based off of a request that they're getting pushback on and not have produced any records that they've actually paid for that did not actually go under protocol for FOIA. EWU should have known that. This should have been filed. They should have given receipts. They should have had audio exhibits. They should have had everything already submitted. Unless they want this to drag on for some reason. And so that's why they ended up filing an incomplete filing, which is what it is, in my opinion, is an incomplete filing. What I don't understand is what the frick makes them think it's going to take this long to get any of this information together. If they already have the freaking requests already like submitted, and it has a list of all of the things that they've been asking for, then what's going to take so freaking long here? What is going to take so long here? This is so stupid. Like, this is dumb. They haven't produced any receipts to say that they've paid for anything. We went through everything that Sarah has. Yeah, dragging this bullshit out. We went through everything that Sarah has on her spreadsheet where she's been putting in every filing. And in none of the filings was there any receipts. No receipts. And that's why I have an issue, because you cannot sit here and ask for things and not pay for them and then think that you have the right to sue. This whole thing could end up being thrown out because they haven't actually obtained any of these things they're saying is highly redacted. Moscow PD is not technically using Pennsylvania law to say that they can't have the damn interview with Kohberger. They're saying it belongs to Pennsylvania. They don't have a copy of it. They weren't given a copy of it. That's what Amber's telling people. That's what Amber's being told to tell people. And when it comes to the pocket recording, that didn't belong to MPD either. That was Gilbertson's pocket recorder. That belongs to ISP. But ISP is telling me that the recording on it, and the transcript that is also in the report don't exist. And they've known for months and months that it's not there because people have been asking for it since those reports came out. Meaning that on their own, knowing for months and months and months and months and months, they haven't even bothered to try to track the shit down. They don't care. They don't care. So I don't know if they're actually quoting Pennsylvania law. I don't think they are. They have not, in anything that I've ever received, it's all Idaho code, ICR, blah, blah, whatever, IC, whatever, however they put it. It's all Idaho code. And then her telling me on the phone, the FBI said so. That call's been recorded and posted. You guys can listen to it. FBI said so. And there's never been another interview with Kohberger and MPD. They've never spoken to him. They've never spoken to his parents, his sisters. They've never spoken to anybody, MPD themselves, besides the one time after his arrest in Pennsylvania. So it's technically not even Pennsylvania law, even if it was something that they're trying to say they're citing. It's the FBI saying that regardless, Pennsylvania can't let it go either. That's why I said I don't want to even waste my time trying to go and subpoena the damn Pennsylvania court, because Pennsylvania technically doesn't have a say in anything because the FBI is the one claiming control. I think the FBI needs to be added as another party to the lawsuit, is what I think needs to happen. Because the majority of this, if not all of it, 99.9% of it's their fault. That part right there too. Like, if it's actually not their case, then why are they the ones who's going through with all of it in that jurisdiction if it's not their stuff? I mean, I want to contact EWU and like see if they'll discuss it with me because of how much we've put into FOIAs and everything else. It's obvious I have receipts to back up what I have to say. Hours of rants about the things that we have proof for. I'm just aggravated at this point. And I wasn't expecting to be aggravated. I wasn't expecting to be like aggravated with EWU. But again, when we go through their list and we see that they asked for 11/12 in September, when we see that they asked for Scott Perky's interview in September, when we see that they asked for the surviving roommate stuff, like months before anyone ever in the YouTube arena of FOIA filing and paying for shit, they had it months ahead of time and they didn't even bother. Connor paid for Scott Perky. We paid for 11/12. Like, did they pay for anything? Or are they just trying to make sure that when they do pay for something, it's not highly redacted the way they see us getting it? I mean, I think that's a valid question at this point because they haven't produced proof that they've paid for anything. And again, we searched around on their whatever call it, and there was nothing on their Whatchy Doodles pages. So I'll try to get, I'll email them and just present who I am. I'm not giving them my freaking information in the first damn email, but I'll just present who I am, what I've done, the stuff that we've received, the stuff that we've handled. Because if they don't have proof of redactions, then what are they going to argue? Because like, in my opinion, they need to show a file. Like they need to produce a redacted file to the court, let the court review it so the court can see how heavy the redactions are. Or else what are you arguing without an example? That's what I was expecting to see today, was some more actual evidence of things. So I don't know. I just don't want this to get thrown out because they haven't actually purchased anything and they don't really have a stance to argue, because we could be going through all of this and then Megan Marshall get all of the documentation and be like, well, y'all didn't produce any receipts. Y'all didn't actually purchase any of this information. You didn't actually purchase the document. You didn't actually purchase the file. You didn't buy the audio. You didn't buy the interview. Because that would kind of like void a lot, I think. And that's the last thing that needs to happen right now. Like this needs to be taken seriously. For real. For real serious. What I don't understand is why the hell Megan Marshall is not making Leander get the hell off the screen. You have nothing and no rights to be there, sir. They didn't even acknowledge that. Did they even acknowledge that? Did they even acknowledge the fact that that ruling had already been made for that person's representees? I don't remember them even talking about it. Because he kept on talking. And now he has a date for when he also gets to file a damn document. Like, they shouldn't be there. The EWU is 1,000,000% right. The way that I worded it yesterday, it's sort of like double jeopardy. Like, you can't be charged with the same thing twice. Well, you can't get the same ruling twice for the same subject. And that's exactly what they're doing. Everything that this argument is everything that Laramie's argument originally was before the Chapins piggybacked onto that one. Leander already went through this with Moscow. For them, he has no right to even be here. He has no right to be filing documents in this case. He shouldn't be there. He should not be there. And Megan Marshall should have handled that. But it's not surprising that she didn't, because she's the one who put the gag order on the case and did everything in the very beginning of all of this. She was judge number one in this entire scenario. Now here she is being the first person to talk here. And she's already pissing me off. She's already pissing me off. Yeah, they said, well, no, not that they want to change the Nevada law. He said that he had an attorney reach out to him and say that the way that the original Laramie case against Moscow went is how Nevada wants to change their FOIA laws now. And Nevada is where EWU is based. I'm not calling them EWU. I'm not doing it. I'm not a freaking cam girl. Okay, not doing it. That's where EWU is based. So it's interesting that they want to change the rules there. But these rules shouldn't be able to be changed. This is a federal stipulation. There should be a federal law that everyone has to follow. The fact that each county can do whatever the frick they want to, each courtroom can do whatever they want to, each freaking district can do whatever they want to. That's why we have all this dumb shit. But that's how they keep the money coming. Because then these stupid ass arguments end up in court. And they get the filing money, and then they get to have another court date, and then they get to pay this person to do this. And oh, now we have to have this person come in and look at this. Oh, we need an expert to come and look at this. That's why they do it. All of this is so unnecessary. So stupid. Dumb as shit. So stupid. Like, this is not going until August. That's the entire summer. Yeah. Leander is there for Laramie and the Chapins. That's why I said he doesn't even need to be up there. He should have been removed instantly. As soon as court started, Megan Marshall should have put it into that. This is so stupid. This is so dumb. The family already, are you talking about the WSU? I don't know. Actually. I don't think there's been anything set yet in that one. I haven't heard anything about a date for anything on that one. I know the last thing that I heard in the WSU situation is that basically both of the things that both parties were trying to file against each other were jointly dismissed. Like, the case is still happening, but trying to force WSU to answer something and then trying to get the venue changed are null and void now. So I don't know what they're doing at this point. I'm not sure what they're doing at this point. But I don't think there's been any more documents since then, which is kind of interesting that it's been at a standstill. Let me go check and make sure that I don't see anything on that end. Nothing recent. Not that I can see. I'll check Pacer, check a couple documents and see what's going on, but I haven't seen anything else happening, which again is odd because they were kind of like filing. And it was like a big thing that people were discussing because it was like happening in the moment. And then it's been like a minute. I feel like it's been well over a month, maybe almost 2 since they've done anything. But I don't know. I don't know what else to do at this point when it comes to this whole situation because we're still paying for shit. And it seems like it's gotten worse. I mean, it's not that it seems like it has. It's gotten worse because now, again, just like that Leander dude is sitting there being like, oh, well, I need to see all this. And what does this document say? Blah, blah, blah. And I need to check and see if it's got something in it, basically, about whatever the family doesn't want out there. That's what Moscow's already allowing. And I don't know how the hell that's legal. Because that's not how it originally was. They did their redactions. Mia was the last person to check off on whatever was done. And then we paid the rest after the deposit. And we got our file the same day that we paid the rest of the money. Now we have to wait an additional week or two because after we've then paid the rest of the money, we still don't get the file until some freaking body's damn family attorney gets to look at it first. That's not how the hell this shit's supposed to work. And then they wonder why we have so many questions. We wonder what the frick they're hiding. Well, maybe if they'd stop being so freaking secretive and dumb, we wouldn't have these problems. Unnecessary shit. Unnecessary shit. For the WSU thing, the deadlines are next week. We'll see what they do. We'll see what they do. Both. She wants a list of what they've received and what like their issues are. And like I said, we've only seen a request from September get a response, but they didn't produce any invoices. They didn't produce any receipts. Like I've showed you guys how they have it with the header on it. They have like the 2 little transaction numbers for their little credit card thingy-mabobber that they use. And it says like what it does. Y'all know what they look like. They didn't produce any receipts for anything. And that's what she wants. She wants receipts, which why I said, I was like, y'all have to be producing something to show like what you are paying for that's not following the line. You can't just say this belongs to the FBI and then sue Moscow because they're telling you that it belongs to the FBI. That's not really stance for anything. So I don't know. I don't know what's going to happen. I like their lawyer lady, the blonde girl. She seems to really know what the hell she's talking about. I just wish that they would have come in with everything so we didn't have to have a continuance. That's why I'm wondering if they actually want one. Because they're not stupid. They knew that they were going to have to produce proof that they purchased things. They knew that was coming. So why didn't they just file it all? They've had time. They can't say Moscow hasn't had time and then pretend like they haven't had time. They've had time. They should know exactly what they're asking for. They didn't file this stuff for months and months and months after that September cost letter. I feel like they should have definitely been more prepared, I guess. Yeah, like I kind of wonder like if they wanted it this way, because I feel like they should have known that. This isn't their first rodeo, you know? Okay. Well, I'm going to go ahead and get off of here. But they haven't, but they don't have any of that though. Like we went through their list yesterday and pretty much everything that they had asked for, they had a response to, including, yeah, hey, this is how much it costs. So even the things that they were told they can have access to, rephrase, even the things they requested that they were told, yes, we have it. This is how much it is to get it. They still didn't go through with that from what I'm seeing. Because again, we paid for 11/12 in November. The rest of it in December. They asked for the shit in September and did not follow through. Connor got the Scott Perkey interview in February 2026. EWU asked for that shit in September of 2025, was told that it exists, was told how much it was going to cost, and didn't follow through. So that's why I have issues with what they're producing. I need to see that they've actually purchased the way that we have and have issues the way that we have, because we are actually getting ripped the fuck off. Okay. We're paying $1,500 for a bunch of redacted mess that's stitched together, that has issues in the stitching where the time freaking goes crazy, that we're being told there's no audio for portions of it. Bullshit. Bullshit. And if EWU would have been the ones to have purchased 11/12, then that exact issue would be being discussed in court right now. But they did it. We did. And now all I can do is file a deadline, file an appeal by June 19th to do anything. And that's with getting that damn fly. It's circling around me because it knows that I'm trying to kill it. And it's taunting me. Your time is coming. Because I'm going to get off this camera in a minute and I'm going to chase you around like a wild person till you're done. Till you're done. This was dumb. This whole thing was stupid. They needed to produce more. This should not have been continued. This should have been something they were ready to go for. It's been months. They should have been prepared. And also, this was filed like in the beginning of April, right? End of March, early April. That means MPD has had months. Mia and her lazy ass ain't going to talk one time during the whole meeting, but needs to be scheduled around her. What the frick was that about? She's had months to address everything that was talked about today. She could have came in and produced more documentation. She could have had more stuff based on the very specifics. She didn't do nothing. Both sides came ill prepared. Both sides came ill prepared. Well, thank you for joining, Miss Cherie. Welcome, welcome, welcome. Welcome, welcome, welcome. And it's gonna hate me before I kill it, because I'm gonna chase it. I'm gonna walk around this room with the damn fly swatter in my hand until it is gone. Gone. And then I'm gonna go feed it to Zelda. I'm gonna go feed it to Zelda. And she's like really dumb, bro. Like, it's not even a joke. She has no idea about anything, how anything works down there. She doesn't care about how disorganized they are. She literally said that I'm the first person to ever say, like, make a comment on how disorganized their office is. How? How am I the first person to tell you how much you suck? There are thousands of us out here that agree that you don't know what you're doing. I highly doubt I'm the first person to be verbal about it. I really do. But when she, as the last check mark on these FOIA requests, cannot even tell me who's responsible for double checking before the FOIA gets sent out, when she can't tell me whose responsibility it is to do what and all the protocols, when she can't answer simple questions about how this stuff happens, then what is the point of you? And she's getting paid $103 an hour to review our damn redacted files. Little Miss Ma'am, who can't even turn on her microphone, $103 an hour. And she can't even answer simple questions about what happens with the FOIA request. $103 an hour. I'm so fed up with stupid. I can't. I'm so fed up with stupid. All right, I'm gonna get off of here though. I got a fly to kill. I have a fly to kill. So I will be back later. If some documents come out, then we'll talk about that tonight. If not, when we're going to move on to chapter 7. We need to get the book done before we get Cyre's book. So we're going to move on to chapter 7. I already have the link already out there. Let me go pop it in the chat real quick. Like my earrings are coming undone. Here's this one for tonight. I think I'm going to try to get a hold of Chief Dollinger again today. Like I'm going to email him. I'm going to forward the email like one more time because he was out of office. And then if I get like nothing for an hour, I'm calling him. Like I have to move forward further and I need to start working on the appeal. Which means I'm going to have to do a live. We're going to do a live one day, just real quick. We're going to do a live one day here soon to where we just like go over some of the Idaho codes and try to figure out the best way to file this damn appeal. Which means I have to go through some more records. I need to go back into the video where we did about the chain of custody for all of that and then add on to it with some of the other documentation that we've received since then, because we do have a couple more documents that include the 1112 stuff. So I'm going to get my files and stuff together. This is so stupid. All right, you guys. I'll see you guys later. Thank you for joining and thank you for the super stickers. I very much appreciate that, you guys. Thank you for watching this mess with me. I'll be back later. Y'all have a good rest of your Monday. Make it great. See you guys later. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that the notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives.